Good afternoon. I am Jeremy Glover and welcome to what is now our 7th Finnick Elliott webinar. In our second webinar, back on 21st of May, we looked at the impact of Covid-19 on construction sites and contracts. Today in the UK, 5 weeks on, the overall landscape is looking rather different, or at least it's about to be very different. But what does that mean in terms of construction projects? Does it mean that everything has changed and moved on? I'm happy to leave you in the safe and very knowledgeable hands of my colleagues John Miller and David Bebb, who will update you on the current position. Just a quick reminder to you to use the question box for your questions, and we'll be coming to those at the end of this presentation. But best thing for me to do now is to say, John, over to you.
Jeremy, thank you for that. Just to explain that this is a seminar, an update on COVID and the way that COVID is affecting the construction industry. Briefly, I'm going to try and steer clear of the law. There will be a bit of law involved. We're trying to explain that exactly what is happening now on construction sites, what needs to be done. And I'm afraid that I can't keep away from the law because there's been a recent case on force majeure that has some bearing on force majeure clauses in construction contracts. My colleague David Bebb will be doing the sexy part of the talk, explaining what to do with new contracts when they're entered into and how to approach it. Very briefly, because a lot has been said, force majeure does not have a meaning in English law. That is the principle that should cover COVID, the delays associated with COVID. You must have a force majeure clause in the contract. The key point is the words that are used in the contract. You need to look at those and interpret those. Now, in a JCT, we just have the phrase force majeure, and in an NEC3, the phrase force majeure is not used at all. Instead, the event must have such a small chance of occurring, it was unreasonable for the contractor to have allowed for it. Now, we have this recent case, which is 2 Entertain Video Limited and Sony. And essentially, what happened there was, this was during the riots in North London in 2011 after the shooting of Derek Duggan. Now, there was a warehouse in North London which contained about £40 million worth of BBC DVDs and videos. The warehouse was looted, it was then burnt to the ground. The fire, remarkably, took 10 days to put out. Now, unsurprisingly, the BBC entity that lost their stock sued the warehouse provider. He said that there should have been adequate provisions in place to prevent the fire. And the warehouse provider had a force majeure clause in his contract. Now, that contract covered any event beyond the warehouse provider's reasonable control. It included, without limitation, pandemic. So in theory, it would have covered COVID-19, but it also covered riot and civil commotion. And it was accepted by the parties that the rioting in North London in 2011 was unprecedented and unforeseeable. However, the warehouse provider lost the case and could not rely on the force majeure clause in the underlying contract as a defense to a claim that was 40 million and slightly came down. The reason being is that it had to be an event beyond the warehouse provider's reasonable control. There was evidence to suggest that previously there had been numerous break-ins to the warehouse. Some changes had been made, that guidelines have been issued as to how the warehouse should be changed. They weren't followed. It's quite specific this. There was also a British standard on fire prevention within warehouses that was not followed by Sony. Quite openly, their experts said they weren't aware of it. So the court found that this was not an event that was beyond the reasonable control of the warehouse provider. There have been numerous break-ins. They should have upped their security and they should have had various fire prevention measures in place, which they would have done if they would have followed the British standard. Now, to try to apply that to construction contracts, what it emphasizes, it's the words that are actually used. Now, I say that under a JCT contract, all you have is the words force majeure. Query if it needs to be foreseeable or not. I'm not too sure it does a COVID event, because there are a few commentators who have said COVID is foreseeable and it may not be a force majeure event. Okay? So it's the wording that's used in the contract that must be looked at and looked at quite closely. Now, by now, I think we all realise that whatever protection you have for force majeure in a contract, you must invoke it. You must have given a notice. I suggest there may be 1 or 2 notices. The first notice when the site shut down to work out what it was going to do, and then possibly a second notice, as in we are now working at 20, 30, 40% capacity, or whatever the case may be. But I'm going to assume that everybody has given a notice now, otherwise they're facing real problems. Now, to put this in the context of what we are seeing, there is still a marked reluctance by consultants to grant even an extension of time at the moment. If you seek advice from a lawyer, first thing he has to say, there is no definitive legal definition of force majeure, certainly under a JCT contract. People are reluctant to be the first. And for what it's worth, I got an instruction yesterday for a force majeure claim. I'm acting for the employer. The consultant immediately passed it on to me and looked for legal advice. He's looking for me to advise whether or not legally COVID-19 is a force majeure event under a JCT D&B contract. Here's the rub on that particular contract. There's a condition precedent clause. The contractor had to give notice within 14 days of the event. Notice went in, I think, on Tuesday, so there may be difficulties just on that point. And I noticed Mr. Bebb grimacing there, but that clause was based on part of his drafting. Okay, now, what we are finding as well, again, is that best endeavours is cropping up constantly. Very often, the first response you get to an extension of time claim is, what are you doing? What are you doing to mitigate the delays on site? And please bear in mind, a JCT contract actually has an express clause requiring a contractor to use best endeavours to reduce the delays. And briefly, there is no definitive legal definition of best endeavours. There is a case which says it is more than reasonable endeavours, and the leading textbook says it does mean that the contractor will have to spend some money, and that's about as good as it gets in the context of construction law. But what I believe that we should be doing now, and I assume everybody has reprogrammed as per SOP 4. I'll look at that a bit more closely in a minute. Staff who cannot come to site are being replaced at the very minimum. And the key point, as always, people say there's a famous claims book which says it's records, records, and records. That's how you successfully maintain a claim. And there's a clear paper trail record of what you are doing to mitigate the delays on site because of COVID-19. Again, straw poll, I'm told that when SOP 3 was in place, Mace said that they were operating at 20% production. It's now between 40 and 60%. It may even be more. Okay. So there's clear delays and disruption to a site, and most contractors, if not all of them, have a duty to use their best endeavours to do something, not simply say, this is it, we're caught by COVID, we're going to go at 20% production, and there's nothing else we can do. So emails re your attempts to get more labour, to reschedule delivery dates, are all important. Okay. Probably like a lot of people, a phrase that I'm starting to use is, I'm suffering of guidance fatigue. There is so much guidance out there at the moment, it's actually quite difficult to follow. We have Public Health England, we have the government document that was aimed at construction, other outdoor activities, and someone made the point immediately that not all construction is outside. And there are numerous HSE documents on their website, but in broad terms, it's the Site Operating Procedure version 4, which is, as I say there, is the go-to document, which most sites are operating under. Actually, I'm not too sure I know a site that's not operating under SOP 4. It has a long list of suggestions. Please bear in mind that the 2-metre rule is a social distancing rule. It does not necessarily apply to workplaces, and there was an exception to the 2-metre rule in the original coronavirus regulations when it came to work. I did have someone trying to convince me once that the police entered into a building site and tried to keep people 2 meters apart and was attempting to find them, but when we investigated it, turns out that wasn't necessarily true. SOP 4, risk assessments are absolutely key. Please bear in mind the point which I mentioned, records, records, and records. SOP 4 says that the risk assessment should be shared with staff. No additional PPE at the moment. Face coverings are not essential, but the existing PPE you need for your site operations should of course be worn. If you can't stay 2 meters apart, SOP version 4 says you need to look at whether you really do need to do that activity, but if you do, you continue and there's certain steps that need to be taken. What's going to be interesting is if we do get this reduction to 1 meter, is there going to be an SOP 5? SOP 4 does mention 2 meters and the rules that need to be taken and changed, but there could be a new version underway. I have no idea whatsoever, but this is the lead document. I would have thought the CLC who published this document will look at those rules again. Now, again, just enforcing the main points, under JCT contract, force majeure COVID-19 gives rise to time only. Under an NEC clause 1960-19.1, it can be time and money. And you are seeing people putting other issues in and trying to raise claims for other reasons in conjunction with force majeure, particularly whether an instruction's been given, are they impeded? If you're a subcontractor and the main contractor tells you to work in a different way, he issues an instruction, is that an impediment under the extension of time provisions in the JCT contract? Please bear this in mind as well. There is a little bit of a push that we're seeing trying to get an instruction to change the way of working. But even if an instruction is issued, that does not mean, eureka, money will follow. In building contracts, it's perfectly feasible to look behind the instruction and what was the reason that instruction was given. So to give an example, an instruction, whether it changes the works or not, and whether it's a variation, you look at the contract drawings, you look at the specification, you look at the reasoning behind the instruction. Just because an instruction has been issued does not give rise to a claim, and that is what is happening too. The other point that's been raised on numerous occasions is, has there been a change in law, to use the NEC wording, or changing statutory requirements under the JCT? The reason why people have looked at that is, again, that can give rise on occasions to money. Now, not easy, but overall, it's not clear there's been a change in law. Many of the existing statutes and what have you have not changed. I'll give you an example. The Health and Safety at Work Act tells everybody to take certain safeguards as far as they are reasonably practicable. That's not changed. What has changed is the guidance from various bodies as to how you safeguard your employees and members of the public, not changing the underlying law. SOP version 4 is issued by the CLC, the Construction Leadership Council. It's a trade body. They're not changing the law, they're giving guidance on how to deal with various regulations. And bear in mind, throughout the course of this, the government has been very keen to keep construction sites open where it's safe. So it is, to put it mildly, difficult to say there has been a change in law, and that potentially could give rise to more time and money. Now, what hopefully is being done at the moment is people are recording what they're doing for any potential claim for delays or a claim for additional money. So again, assume that what we have been seeing, our jobs are being completely reprogrammed in accordance with the site operating procedure. I would expect a detailed weekly, daily site diary, query, possibly sent to the employer, or if you're a subcontractor, onto the contractor, explaining exactly what is happening on site, why you can only get 6 people in that particular area where you should have had 10. Copious photographs, you see those quite often, of what the problems were, because what you're aiming for is an as-built, exactly what is happening on site, with documents together that show This is why it had to be done that way. We had no other option. Okay. My next point is really about the most common mistake we see, which is not keeping costs separate. In the sense of, by now, costs that are associated with delays relating to COVID-19 should be entirely separate from the other costs of the job. Otherwise, it'll be very difficult to prove that delays or costs were incurred as a result of SOP 4, government guidance, keeping 2 meters apart, having to delay deliveries, there's not enough on site, or whatever. That's absolutely imperative to make sure all suppliers, all subcontractors keep these costs separate and records of delays separate as well. And again, just a slight bugbear of mine, hopefully we are seeing proper timesheets. We often see timesheets that say that everybody has worked 7 hours a day, but never tells you what they're doing. My last point is this: all of this does not have to be done aggressively, and the hope of the industry, if you look at the Cabinet Office guidance, the RICS documents, is that people will start to talk to each other. We can't just fall into a dispute, everybody adjudicating against each other. So the idea is that there needs to be people speaking to each other to try and work out what they're going to do, and there are various proposals from trade bodies. But for what it's worth, you can look at the CLC contractual best practice to declare we've had a hand in, but gives an idea not only about notices that should have been given, but how you can actually approach negotiations in a without prejudice and subject to contract manner, without prejudice your position. Okay. That's a quick run through of where we are at the moment. David, over to you.
Thank you, John. Right, so John has run through the position under existing contracts. What I will be looking at now is what do we do going forwards on jobs that are about to start. It's always worth a reminder at this stage, and it was probably John that rammed it home to me when I first joined Fenix probably 15 years ago, the second bullet point. It's all about the contract and the fact that English law allows you to divvy up risks as you want to. Okay, so I think it's fair to say in the last 8 to 10 weeks there've been more contracts dusted off and found in old site porter cabins than ever before in the history of the UK construction industry. And they've done that just for a reason, which is because it's the contract that divvies up the risks. Okay, and more or less what English law says, you're all grown up, you can divvy those risks as you wish. And if you sign a particular contract that that places all the risk on your shoulders, so be it. There's very little scope to come running back to the court and say, well, this is terribly unfair, I never foresaw COVID coming, etc. John's already made the point that if you don't have a force majeure clause in your contract, query what ability you've got to do it at all in terms of claiming any time. I mean, in very simple terms, it's almost probably fair to say as well that as a general rule, if the contract doesn't divvy up the risk, it's fair to say that most of it probably sits on the contractor's shoulders. If the contractor's agreed to fit out 10,000 square foot of space for £1 million in 12 weeks, unless the contract says otherwise, that's what they have to deliver. And the fact that there's difficulty in getting the materials, the fact that safe operation procedures cause a problem, or whatever it might be, the employer can sit there and say in week 12, why isn't it finished? Okay. So it's really, really important that the contract is the most important document to point to. If there's a risk and the contract doesn't deal with it, the contractors on this webinar should probably assume most likely sits at their doorstep. Now, over the last sort of 12 weeks, I have been asked by a number of contractors and clients, well, is there some simple wording, Dave, that could fix this? You must have done it 1,000 times before. If only there was. The reality of it is, of course, that every job throws up something different. So my fit-out contractors fitting out the 30th floor of a 50-story building in central London throws up many different issues to the groundworks on a greenfield site out of town or from a job in a residential area. There's always something that it throws up something different. But what you must do is, and contractors are usually pretty good at this, is look at the job with your glass half empty. As my wife points out to me, I was born with my glass half empty, but that's my job, is to see, well, actually it could go pear-shaped here, here and here, and if that does, point to a clause in the contract that says if it's my lookout or somebody else's lookout. So you've got to look at it with your glass half empty and see, right, this is where it could go wrong. Contractors have always been adept at risk registers and working out what could go wrong. What they should now have, of course, is a separate little section tagged on the bottom that is COVID-19 related risks. What if the site is shut down? What if I have to self-isolate like half the staff? What if the materials don't? So all that sort of thing needs to be on the bottom of that risk register. Okay. Now, again, coming back to a sort of more general point, as construction lawyers, and there's a good few of us in Fenwick Elliott that we have the same problems. If there's a dispute on the job, we ask for the contract. That's fine, great. We can find that in a porter cabin. But what we frequently find, of course, is that when we look at that contract, it's very evident there's been all sorts of fingers in the pie in pulling that together. So the lawyers have done the legal bit, and the estimating bit have done the pricing bit, and then the programming people have done the programming bit. And then overall, there's some commercially, there's some assumptions and qualifications around the price. That's all bound together in a lever arch file on a Friday, ready to be signed to start on a Monday. When we actually come back to it and look at it 6 months down the line, all these bits of the contract say different things. It's really important if you're going to get these qualifications in there, that they're properly incorporated in the building contract and don't say something different, because it's the second thing in our list in terms of what causes disputes is the contract not being in place, or if it is in place, it's saying different things. So what are we seeing now in terms of typical assumptions and qualifications to the price? Well, John's already touched on the fact that the one certainty that I think has come out of this, and it is the only certainty now, is that contractors are pretty adept at working out what the current social distancing rules do to the price in the program. John mentioned a certain productivity rates, and it does vary hugely depending on the project. So where we've come from the last sort of few months now is that we're now finding that contractors are pretty accurate at saying, if I'm working to version 4, as John talked about earlier, this will cause the program to go out by this much. Okay. We're actually ironically finding that some projects are easier. So, for example, I've got work in central London where obviously there's no issue with traffic. There's very little issue with noise. The buildings are occupied. Actually, do you know what? That allows us almost to go at pre-COVID speeds in terms of getting that work done. But where does my contract deal with the fact that what happens if tenants start to come back into the building? What happens if a landlord imposes different obligations on how work is carried out in that building? All these sorts of things need to be thought about, because again, with your glass half empty, it's great now driving into central London and working, but that might not be the case in 10 weeks time or 12 weeks time. Okay. The one uncertainty, I'm not sure, I'd welcome thoughts from others in terms of the availability of materials. Certainly when I did the webinar a month ago, there was a whole issue around plasterboard and getting various bits of materials. The one key thing, of course, is any main contractors will phone a supplier, and the supplier, of course, doesn't have an answer. They may say at the moment it's fine, but no promises. So how is that message relayed from the main contractor up to the client? All we are finding, of course, is that orders don't half reach the top of the pile if some money changes hands. If you want some certainty, some money flowing down the supply chain can ensure that certainty in quite a good way. Just on my final bullet point, the reason this is all important is the point John touched on, because if things change between now and the end of the project, to show a change, I need to be able to show where I started from. So in terms of me going, well, I'm currently working to COVID-19 version 4, I need to show what the impact that is and what I've allowed for, what I haven't allowed for, to then be able to show if it becomes more onerous on site and more restrictive, it does this to my program and my price. Okay, now it sounds obvious. My next bit here is in terms of when we're actually starting. It sounds an obvious question, but certainly in the middle of COVID-19, a lot of the jobs that were sort of at handshake stage stopped, okay? And it stopped while the employers thought about what to do, okay? What we're now seeing now, I'm seeing a lot more sort of confidence in jobs are now being signed, and there's a lot more confidence now, because I think in terms of certainly the impact on the program, it's leveled out a little bit more, there's a bit more certainty. But just bear in mind, of course, certainly in JCT, the thing that starts your program is your date of possession, okay? Now, usually that can be just glanced over because the employer is chomping at the bit to start, and so is the contractor, okay? I'm not necessarily sure that's still the case, or are there some more caveats around when the work starts? For example, in the fit out side of life, if the base build has been delayed, can the tenant employer still guarantee possession on a certain date, or does the employer want some more flexibility in terms of when possession is given? Okay. Likewise, what I saw sort of 5-6 weeks ago was the client wanting a lot more flexibility on when that date of possession is. Okay, so they're happy to sign a deal now, but what they're saying is possession is pushed out a bit. So from a contractor's point of view, have a think about how that affects our price. Can we wait indefinitely for possession? Also, from a contractor's point of view, think about it in terms of, say you are signing a project now with a date of possession in, let's say, October, okay? What could happen between now and October that affects me as a contractor? If we get a second wave, what happens? Are there certain things on my wish list as a contractor I would like to see happen before possession is triggered? Because what could happen, of course, is we end up getting a second wave, and actually we end up in a worse position on site in terms of it being more difficult to do the work and it's less productive. But if that date of possession is triggered as a contractor, my program is ticking, okay? As I said in the second bullet point there, we get some contractors are asking for long stop dates. If you've not made your mind up by now, this is what happens. Is it a price increase? What happens? Okay, we've got certain bits in terms of a checklist for possession. So rather than the contractor dictating where possession is or the employer dictating when possession is, it's a tick box exercise. Once we've got certainty over materials, once we've got this, once we've got access, possession is granted, and that starts the clock ticking. But again, in my final bullet point, all these things need covering in this contract because all JCT says it's just one date on one page of the contract particulars. And if you glance over that, as you might have done in pre-COVID days, just think that's the clock ticking as soon as that date is hit. Okay, you just do the next slide for me, please, John. Okay, when are we finishing? Again, I think before lockdown happened, there was a very simplistic view of COVID-19, which was, well, I'll tell you what, we'll program as we know for things at the moment, and if it gets worse, the contractor gets some time, maybe no money. It's a lot more sophisticated now in terms of how contracts are amended to deal with this. So, for example, we know, as I mentioned before, we know we can estimate the impact of the current social distancing, so we need to think about how we benchmark a change to that. We're also seeing clients actually thinking, well, actually, if it gets better, what happens? So at the moment, we're on SOP version 4. If SOP version 5 says, actually, do you know what? We're going to relax some of this. What happens? Some clients are looking for, well, I'm going to be looking for a saving on the prelims and the program, okay? Again, needs to be dealt with in that building contract because from an employer's perspective, the contractor wouldn't be giving any money back in that situation. I mentioned on the last webinar the relaxation of working hours. What local authorities are now doing or now allowed to do by government to encourage construction to get back to full speed and catch up on the lost time is relaxing the working hours. Just be very careful from a contractor's perspective, assuming that you can rely on those. You may well have a typical building contract will say, well, as long as you work within the statutory requirements, that's fine. Okay, so if the government do relax it, you'd still be complying with the law. Just double check what the prelims say in terms of what the permitted site hours are, because that might be more restrictive. You'd then be reliant on going back to the client and saying, well, actually, we'd like to work longer hours to recover the time lost. Now, of course, in most situations, a client will nod and say, of course. One of the questions we got asked last time was whether that amounts to an instruction to accelerate. I think the clear answer to that is no. It is merely the client saying, well, yes, the hours are normally this. I will let you work longer if you wish. That's not the same thing as an instruction to accelerate. Now, in most cases, I can see no reason why an employer would not agree to the relaxation, apart from potentially maybe the area of the site. If it's a residential area, think about some of the issues that arise. So don't assume that in order to recover time, you can work longer hours, because you can recover an awful lot of time by it's an extra sort of 4 or 5 hours a day. There's a lot of time to be recovered there, but don't assume you can do it without the contract dealing very clearly with it. Other things to think about that in terms of things getting more sophisticated, what we're seeing now as well is contractors being given a bit more flexibility to substitute materials. Now that will depend whether it's traditional or D&B, but generally speaking, of course, as long as if a contractor's promised product X, exactly product X has to be approved and supplied. So think as a contractor, do I want a bit more flexibility to swap out this for this? And how do I want the client to agree? Or do I want the client to be able to say, actually, do you know what, if you're suggesting a contractor, it's almost de facto it is done. We as a contractor are allowed to substitute certain things, okay? Just think about that. Likewise, what we're seeing as well is, can we still get practical completion if elements of the work are not there, but they've been delayed by COVID-19? So think about the fit out market. There could be some specialist joinery that's not turned up, or specialist light fittings not turned up. Is there a provision in that contract we can say you will still grant us PC, even if this bit of kit has not turned up, and it will be installed effectively as a snag? later on. But again, you must bear in mind that all these points are not covered in a typical building contract. For you to change materials as a contractor, or to effectively say you'll still give me PC even though half the stuff is stuck on the board in Italy, you need the client buy-in to do that. Okay, John, the next one. Okay, finally, I mentioned materials. I've seen a few sites where, in order to mitigate the risk of either material availability or, more importantly, the price, I mentioned the money flowing down the chain to secure that. That brings out all the usual issues, of course, of money changing hands before anything has been either delivered to site or built on site. Okay, but it does mitigate practically quite a bit of risk, because I've got certain sites where if there's enough space on the site, we can store materials on the site. Yeah, just bear in mind, doesn't mean we'll get paid for them, of course, as a contractor. Just bear in mind how the valuation mechanism works. It says we will certify and value the materials provided they're not brought to site prematurely. If we're still piling the site, we're not going to get paid for the roof tiles. Okay, but it's a little tweak we could make to make sure that we do get paid for the roof tiles while the piling rigs are still on site. Think about this second wave of coronavirus. I've already mentioned this before in terms of, if I'm due to start in September, what happens over the summer? There was something in the press yesterday. There was a photograph of Bournemouth Beach. It must have been everyone about half a metre apart. This second wave thing, it's almost ready to see happening in terms of looking at some of the photographs in the press yesterday. Think about how the contract deals with that. Remember, JCT, I think, allows either party to walk away once there's been a prolonged suspension. We're seeing that changed again. So is it being 4 months? Is it 6 months before either party can decide to walk away? My final bullet point, John's already mentioned some of the difficulties in demonstrating what a best endeavours obligation is. Unfortunately, the law is not particularly helpful to anybody in the construction industry in terms of working out precisely how much money does that mean. There's certain, as John mentioned, certain textbooks say it can involve spending some money, but maybe not a significant amount. I've got a project now where the contractor, in order to allow pedestrian movement around the building, a certain one-way system, they put a hacky staircase on the side of the building. That's £8,000 worth of scaffolding. Is that best endeavours or not? Yeah, unfortunately, it's very difficult to quantify it. The only way you can quantify it, of course, is write it down in the beginning. So there's nothing stopping the party saying, my best endeavours obligation on this building site involves me doing this, this and this. It does not involve me doing this, this and this. If you can strike a deal along those lines, that will put to bed, at least for a while, all the difficulty around arguing what a best endeavours obligation is. So am I supposed to buy my roof slates from North Wales at twice the price than waiting for the ones coming from China? Yeah, is it something I've got to do? It's very difficult for the law to give you a definite answer, but if you write it in the contract, it will go some way to creating some sort of certainty. So the next slide, John, I think that's probably client direct work on site. We touched on earlier. Frequently, building contracts will allow the client to send their own workforce onto site. As a contractor, is that something I want? If I know that the current social distancing rules only allow me safely to have, say, 30 workers on site, do I want 30 of my own, or do I want 25 of my own and 5 of the client direct? Again, it's another impact of how this happens, of some of the sort of knock-on effects of COVID-19. For those who do regular work for the same clients, it's often the case, isn't it, that the same amendments get trotted out each time and they're given a cursory glance. Well, you've accepted them before, please sign again. Just think what might have been acceptable pre-COVID-19 may no longer be. So, for example, there's often a little change in there along the lines, well, you've allowed for all the changes in legislation that are reasonably foreseeable. It's a nasty little sting in the tail there. Almost all changes in legislation in relation to COVID-19, I would argue, are reasonably foreseeable. And John mentioned the point, actually query whether there's been a change at all. What we're really interested in is the government exercising a power they already have. So it's either, is it a change that was foreseeable, or actually exercising a power they already have? Just have a think about that when you're next flicking through it. Contractors, of course, have got all the same issues to deal with down the line with subcontractors. So don't forget, your sort of admin up the line is great as long as it's mirrored down the line. Okay. So all I would say, just to sum up, very few contracts are going to deal with all the complexities that are thrown up by COVID-19. And on top of that, they will not deal with all the specific things that you could agree with a client in terms of what happens if. So it really does pay to get your sort of glass half empty list, write it down, and if that risk appears or arises, can you point to a clause in the contract that divvies up the risk either client side or contractor side? Because without that, it's probably safe to assume that it will sit on the contractor's shoulders. I'm probably not a million miles off time, Jeremy, I don't think.
No,
So on that
that's
basis,
absolutely perfect.
it's a
Thank you.
questions time, isn't it?
Yep, perfect. Thank you both very much, and thank you those listening who've been submitting some questions. Just very briefly taking up a point that you made, John, about notices and suggesting that it may be too late to be serving a notice. We've had a question, and it's very similar to a question we've had on 2 or 3 other previous webinars. Does an email simply stating that COVID-19 is going to impact the project serve as a notice?
Unlikely to. For one, you need to just check how you can give notices under contract. I think JCT, Jeremy, any effective means now it's been changed. But then a notice under a JCT contract normally has to say how's the progress of the work's been delayed, also, and is it a relevant event? It's not good enough to say we've been delayed by COVID-19. So I've got some doubts about that.
I think just to add to that, John, is there's no rocket science in writing these notices. I think frequently, the point is to bear in mind that the clause gives you all the clues as to how it needs to be read, served, and what it needs to say. All you need to do is find the relevant clause and just do exactly as it says. If needs be, use the same wording. If to be absolutely clear, say this is my notice under clause blah. And it goes a long way to getting it being a compliant notice rather than just an email that bears no resemblance to actually what the clause asks you to do. As again, there's no magic in this, just find the clause and just follow what it needs to do.
Yeah, no, I mean, that's absolutely right. And the other thing you need to be thinking about as well is who you send the notice to. Quite often tucked away in your contracts, there'll be quite a specific requirement that notices have to be sent in a particular way or to particular people. And sometimes they're not the people you deal on a day in, day out basis on site and on projects. It's interesting that question keeps coming up. It's just such an important thing. Moving on slightly, John, you talked, sorry, it's you again, John. You talked briefly about the possibility of there being an SOP 5. Now, quite a few contractors have been looking at SOP 3 or 4. They've been preparing programs, and sometimes they've got programs accepted under SOP 4. Then SOP 5, in theory, it comes along. If that changes the way in which work is allowed to proceed, would that constitute a, I suppose, inverted commas or capital C change from a contractual point of view?
It will always depend. Sorry, Joe.
No, go on.
It always depends on the terms of the contract. Okay, because what you're just one point there, you're not necessarily changing the works themselves, but what you're changing is the how you're doing the works. So in itself, I'm struggling with the idea that that would be a variation, because you're changing how the program is built, so how the building is built, the timing of it. I would say it's exactly the same when SOP 1, 2, 3 was out for about 4 hours, I think, then it was withdrawn. 4 comes out. You've still got the same arguments that we've highlighted there. Is this a change because of COVID? It is. Should be a force majeure event. But is it a change of statutory requirements? SOP 5 comes out.
Maybe not. This is exactly the point, Jeremy, why it's so important to benchmark what we have allowed for. So to come to that point, we've allowed for version 4. We've written that somewhere down in the contract, however it's incorporated, this is what it's based on. And my time event says, if that changes, that's what gives me the time. Because without it, you are scratching around for all the arguments that we've been scratching around for on contracts that don't deal with COVID. Is it a change in law? Maybe, maybe not. It's a guidance. So all those arguments and grey areas can just be got rid of completely if you actually just pay attention to precisely what is my program based on, and if this changes, this happens.
So I just said I've got some real sympathy for people there, because the HSE has said it's going to enforce SOP version 4. So you've got to comply with it, and then that's what people are saying. Is it a change in law? So I presume the HSE will be saying SOP version 5. They'll be enforcing that as well. So there's not much.
I mean, it's true. And again, awful lawyer's answer. It does depend on the type of contract you're looking at, because the FIDIC contract, for example, has quite a wide, and in this particular situation, more generous definition of what a change in law might be, and it seems to incorporate more easily things like sort of general regulation. So again, for probably, I apologise about the 5th or 6th time in the last half an hour. It does depend on what your contract actually says. Perhaps as a final question, there's some, I think, mentioned, and that's largely because Dave covered off in his talk in quite detail about the extended working hours. There have been 2 or 3 questions came in about that, but I think Dave has actually covered off the position in relation to that. We mentioned the guidance, and we mentioned the idea that government is promoting not to be aggressive in your approach to dealing with issues relating to claims that are being made as a result of the COVID-19 position. Do you think generally, is there an appetite for parties to sort of reach a sensible agreement in relation to potential disputes or potentially redistributing risks moving forward, or is it something that's actually a little bit too early to say at the moment?
To be blunt, my experience at the moment is people are they're not really too sure how to do a deal because we don't know how long this is going to last, and it's quite difficult. We have been involved in a couple of deals. Dave's been involved in some, I know, but one of them's fallen apart with one of the leading airlines that suddenly decided it couldn't pay anybody for their building works. So at the moment, people are still finding their feet, but eventually someone will break cover, I think. And it comes a point in time you just can't keep doing a notice, yes, change in law. I've seen so many letters on change in law backwards and forwards. Someone's got to, have to nail their flag to the mast. Dave?
So what I've seen, a few jobs actually, there have been. So I think what happened early on in COVID-19, when we had the sort of lockdown of sites and contractors stopping on site, often probably prematurely. So I've had sites that have stopped for maybe 4 weeks, and what's happened then is actually the contractor and client have agreed then that actually is a time event. Okay. Now bear in mind the difficulty that John mentioned in his talk about actually whether it's a force majeure. If I were a contractor and someone offered me time of 4 weeks without an argument about force majeure, I'd snap their hand off, I think, is the first point. So if I can get that recorded somewhere that says, you'll give me the time for 4 weeks, that's great. Got to think then about, well, what happens if it happens again, right? So is it a force majeure if it happens again? Maybe not. Would I want something in my little side letter that says, I've agreed that it's a time event here. Just to be clear, going forwards, it's also a time event, Mr. Employer. Yeah. So if I get my second wave, that's also a time event. You've accepted it's a time event here, but what about the next 50 weeks of the program? Yeah. But again, it's all about what you write down. If I can get a side agreement that covers off what happens while I was suspended and also what happens going forwards, that's what you need to try and do.
Okay. Thank you very much. I mean, I think that suggests that very strongly what we should do is invite the two of you back in sort of 6 or 7 weeks time for a further update so we can actually sort of see what is actually progressing. But thank you, John. Thank you, Dave. Next week, something slightly different when I'll be joined by Dr. Stacey Sinclair and Mark Pantry, and we'll be looking at BIM. And some of you may have noticed or been aware that a new information protocol came out at the beginning of the month, and we'll be discussing what that means for construction projects and construction contracts. So hopefully you'll be able to join us all next week. So thank you, stay safe, goodbye.